everybody. My name is Benjamin Lawrence. I'm a professor in the history department, and I'm also a 1L here in the law school.
Wow.
Super exciting that my first semester in law school, and I'm loving it. And I'm also eating my lunch. I apologize about that because I had planned on having a sandwich, but somebody ate it. I'm not going to say who, but there's only one other person who lives in my house. So I'm very pleased that Professor Marouf has agreed to join us today. This is the second installment of our Bacon Immigration Law series at the University of Arizona. And the third installment will take place on October 30th. So if you haven't already clicked on the link to register, please do so. I'd like to thank all the organizers, including Carol Lee and Shafali and Philip and Eunice and Professor Dean Miller and everybody else who has made this come together. So thank you very much for your efforts. And so allow me now, please, to introduce Professor Marouf. Professor Marouf has since 2016 been a professor of law and director of the Immigration Rights Clinic at the Texas A&M University School of Law in Fort Worth, Texas, where she teaches immigration law and as well as legislation and regulation. Prior to her appointment at Texas A&M, she was an associate professor of law and co-directed the Immigration Clinic at the William Boyd School of Law at the University of Nevada, Las Vegas. Professor Marouf has a BA in English from Yale and a JD cum laude from Harvard Law School. She also has a master's in public health from the Chan School of Public Health at Harvard. Professor Marouf has a distinguished national and international resume. She was named an American Association of Law Schools Bellows Scholar. She has taught in International Comparative Human Rights Law Practicum in New Delhi. And before entering academia, she worked as a staff attorney for the California Rural Legal Assistance. She clerked for U.S. District Court Judge Consuelo Marshall in the Central District of California. And she practiced as immigration lawyer in Los Angeles, focusing on asylum and deportation defense and federal appeals. Professor Marouf has argued or otherwise contributed to a number of important immigration precedents, including the matter of ARCG, which established the precedent that domestic violence can be a basis for a grant of asylum, and the matter of MEVG that clarified the meaning of PSG, the subject of her talk today. Professor Marouf's research and writing focus on immigration and refugee issues, as well as the psychology of decision-making. She has published a number of influential articles, including in the law reviews of Tulane, Cardozo, Boston University, Florida, Washington, Cornell, Georgetown, UCLA, just to name several. Her work on PSG claims, particular social group claims, including an article on constrictions on the PSG category within the United States, first drew my attention to her work, and that appeared in the North Carolina Journal of International Law. Professor Marouf is an active member of several professional associations, including the ALS and the American Immigration Lawyers Association, where she previously served on the Detention and Removal Committee. She's also served as a consultant to the UNHCR, but her connection to immigration law is also deeply personal. As a first-generation American of immigrant parents from Egypt and Turkey, she's passionate about using law as a tool to empower people and create social change, employing an interdisciplinary approach, engaging science, social psychology, and the humanities. Today, she's kindly agreed to share her thoughts with us about her work on PSG, a particular social group with respect to refugee and asylum law. I'll ask you please to mute your microphones if you haven't already, and I'll be taking questions at the end. So you can post those in the discussion or you can send them directly to me. Please join me in giving Professor Marouf a virtual University of Arizona Law School warm welcome.
Thank you. Thank you so much. That was such a kind and lovely introduction. So I'm going to talk to you a little bit today about the membership in a particular social group, or PSG, ground for asylum. Would you just mind raising your hands, either using the little function or visibly, if you have any experience with the PSG ground in any cases you've seen or read about, if you've heard about it before? Some of you have, yes. I know the faculty has. There's been a lot of evolution of that ground over the past decade, and particularly since 2008 or so. So we'll talk about some of that, how it's changed, and a little bit also about internationally and comparatively what's been going on. So I'll start out and give you all an overview. We'll do some hypos at the end, and then we'll just open it up for some Q&A. So I'm going to go ahead and share my screen here. Hopefully this will work. Okay, let's see here. All right, can you all see this? A little bit. Okay. So as you may know, there are 5 grounds for asylum: race, religion, nationality, political opinion, and then the one we're talking about today, which is membership in a particular social group. And for obvious reasons, this one is a little bit less intuitively easy to understand, right? It's at first glance, most people don't know what it means or what kinds of groups are included. So it was sort of left intentionally open at the time that the convention was drafted, in order to allow for possible future events, conditions that perhaps were not imagined at the time in 1951. So you may have heard a little bit already from Professor Masallo about the history of the convention, so I'm not going to get into that too much, but basically it was after World War II that the convention was created, and neither the convention nor the protocol that was issued in 1967 defined a particular social group. So in the US, this is defined based on case law. Our statute and regs also don't define it. So we're really looking exclusively at decisions by the Board of Immigration Appeals, which is the administrative appellate body, or by the federal appellate courts, which review decisions of the Board of Immigration Appeals, to understand what a PSG is. And the first characteristic that came to define a PSG back in the 80s is something called immutability. And that came out of a case called Matter of Acosta that the board decided in 1985. That case involved taxi drivers. And that was sort of the seminal case where the board applied a statutory interpretation technique called the justum generis that you may learn about in classes you take on statutory interpretation, where basically the board looked at the other 4 grounds for asylum: race, religion, political opinion, nationality, and said, what do these 4 grounds have in common? And it decided what they have in common is a characteristic that either can't be changed, so it's immutable, or that you should not have to change because it's fundamental to your identity. And so the board said, okay, we're going to define membership in a particular social group the same way, based on an immutable characteristic. And for many years, up until the 2006 or so is when it started shifting, that was the definition of a social group. And in Acosta, some of the examples given included sex, color, or kinship ties. And so kinship ties helped establish family as a social group. And you'll see, even though sex was listed in Acosta, there was still a lot of resistance to having sex or gender alone define a social group. So it's been done, but it is, it's not common for courts to do that. The other type of immutable characteristic that Acosta mentioned was a shared past experience. So former military leadership or land ownership, something that's already happened in the past that defined your status and that now cannot be changed. So soon after Acosta, or in the years following Acosta, I should say, as early as 1990, sexual orientation was recognized as a social group. This was at a time when being gay was still a bar to coming to the US, but we recognized it as a ground for asylum. And then numerous circuit court cases after that also recognized it. Family, as I mentioned, clan membership was recognized by the BIA and also by circuit courts. Land ownership, so cattle farmers, for example, in Colombia. And in terms of former status or occupation, things like former members of the police, former child soldiers that the Third Circuit recognized, and former employees of the Attorney General's office in Colombia were recognized. So these are some examples. There were also gender-defined social groups that were recognized. So Marouf Kasinga was sort of the first major case, and this was an FGM case, so female genital mutilation or female genital cutting, FGC. And the way the group was defined there was a little bit convoluted, but it was women of this particular tribe who had not had FGC and who opposed it. In the years that followed, other groups involving gender, usually combining gender with something else. So in this case, in the Seventh Circuit case noted here, sort of refusal to comply with Islamic dress. There's also a Third Circuit case called Fatin, F-A-T-I-N, where similar sort of resistance to Islamic social norms combined with gender was used to define the social group. So then around 2006, the BIA started adding things to the immutable characteristic definition. And the earliest case, I believe, is a case called Matter of CA. And that was introduced in 2000, oops, sorry, skipping around here unintentionally. That was introduced in 2006. I'm going to get into that in the subsequent cases. But first, I just wanted to give you sort of a broad overview. So the two additional factors that have now been added as requirements basically to the social group definition are what's called social distinction and was previously called social visibility. So what that means is the society in the country of origin, society as a whole in the country of the origin, must perceive the group as distinct from the rest of society. And this isn't limited to the persecutor's perception, but society as a whole. And the second requirement is called particularity. And this means that the boundaries of the group must be clear. So we should be able to tell who's in the group and who's out of the group. Now, if you're a little bit confused looking at these two things and wondering how they're that different or if they're different, you're not alone. So attorneys were completely flummoxed by this, and so were courts. When these first came out, it was very unclear what they meant. The definitions that I'm giving you here is after years of sort of explanation by the board. So this is the end point, not the starting point. In the initial decisions that the board issued on this, the board purported to rely on the UN's definition on UNHCR's own social group guidelines. But in those guidelines, the UNHCR, so the UN High Commissioner for Refugees, actually puts forth two alternative approaches. It says a social group can be defined based on an immutable characteristic or based on social perception. But of course, the BIA took those two things and replaced the or with an and made this a double requirement. And the social perception notion actually came out of largely Australian interpretations that emphasize social perception, but even the Australian High Court, which is like their Supreme Court, basically said it's not required, it never required perception. But that way of approaching a social group, the UNHCR included as an alternative because it was something that some countries were doing. But the dual requirement was unique to the BIA. The board also then looked at the EU Qualification Directive, and this was the second place that it found support. This was issued in 2011. So after the BIA had already started doing this, the EU Qualification Directive sort of shored up the BIA's view, because what it did was it included the word and between these two. So it defined a social group as, it says the group shall be considered to form a social group, or in particular, one, the members of the group share an innate characteristic. So something, a common background that can't be changed, shared characteristic or belief so fundamental to identity or conscience that a person should not be forced to renounce it. So that's exactly Acosta, right? But then it said, and that group has a distinct identity in the relevant country because it is perceived as being different by the surrounding society. So this looks exactly like the two different tests, the social distinction or social perception test plus the immutability test. And that's something else that gave the board sort of support to say, see, we're doing it the same as Europe is doing it. But what the board ignored is that countries like the UK, so the country we probably draw on the most in terms of our case law, that the UK House of Lords, which is their Supreme Court, right, had interpreted the Qualification Directive. So it read that and as an or. And it said that and should be an or to be consistent with UNHCR's approach and the fundamental protections required by this convention. So the UK did not follow that interpretation of the EU Qualification Directive, even though the word and was in there. So back around between sort of 2010 and 2014, there was a lot of litigation trying to figure out what these things meant, social visibility and particularity. Some of the briefs that I submitted drew on international interpretations of other countries. And so we looked at both common law countries and non-common law countries. So the common law countries tend to sort of have the most weight because they have the most similar case law to ours. And we tried to show that in all of these countries, really, it was the immutable characteristic alone that could establish a social group. And even though some countries did also consider perception, it was never the same kind of double requirement that the BIA imposed in the United States. So the first decision that came out in 2006 was very unclear. It didn't, I started writing a law review on this at that time. This is before I went into teaching. I was still practicing, and I saw matter of CA come down, and then this next case I'm going to talk about, matter of AME. And I was like, what's going on here, right? Because it started talking about social visibility and particularity as factors. So the board didn't even say they were requirements yet. It was sort of working its way up to that. But in CA, it was, the PSG was defined as non-criminal drug informants working against the Cali drug cartel. And the BIA said it lacks social visibility because the nature of being an informant is being secretive. So it sounded like literal visibility, right? In a sense, like because you don't know who's an informant, you can't have that be a socially distinct, or in that, at that point, it was still being called social visibility, so not a socially visible group. The BIA also said it wasn't particular enough because it was too loosely defined, but it didn't really explain the analysis there. So shortly thereafter, in 2007, we have AME and JGU. This was a case where the social group was defined as affluent Guatemalans. And again, the BIA introduced this concept of social perception and said there was no evidence that society views affluent Guatemalans as sort of socially distinct from the rest of society. And it also thought the word affluent, like wealth or affluence, was too amorphous or indeterminate or subjective a characteristic to define a social group. So it wasn't particular enough. So then there were a couple cases, matter of SEG and matter of EAG. I don't think I included EAG in my slides, but they both came down in 2008. And so in SEG, it was, the social group was defined as Salvadoran youth who had rejected or resisted membership in the gang based on their personal, moral, and religious opposition to the gang's values and activities. And the BIA said that group lacked visibility because society didn't see those people as a group. So that wasn't perceived as a group by society, and it said it was too amorphous. So somehow the words being used in defining the group were not specific enough to identify who is in the group and who is not in the group. But the BIA didn't phrase it quite as clearly as I'm phrasing it now. So after that, what happened was there was a circuit split. There was all the litigation I was telling you about, a lot of amici briefs filed, and two circuits rejected social visibility and particularity, the 7th and the 3rd. And the 7th Circuit's decision in Gatimi basically said that the BIA's analysis made no sense. And it said the BIA did not provide rationale. It doesn't make sense because targeted groups take pains to avoid being socially visible. And it's also contrary to BIA precedents because the BIA's previous decisions had never talked about these requirements, and some of the groups were arguably never socially visible. And in a later decision, the board also, the 7th Circuit, also rejected particularity. And then the 3rd Circuit rejected these requirements in a case called Valdivieso-Galdames. And there the PSG had been Honduran youth who had been actively recruited by gangs, but who have refused to join because they oppose the gangs. And this case was then remanded to the BIA, and this is the same case, that's matter of MEVG. So the VG is the Valdivieso-Galdames. And so we'll come back to that case in a minute. Other circuits also address these requirements, but all the other circuits accepted them. The 9th Circuit accepted them, but it did clarify some things. Like it said in Enriquez Rivas that a PSG does not need to be homogeneous. which the BIA suggested it did in some decisions and rejected in others. The Ninth Circuit also said that in its view, it should be in the eyes of a persecutor, whether the group is perceived as a group. But it wasn't ruling on that. So it kind of left that for the BIA to decide. And as we'll see, the BIA did not adopt the Ninth Circuit's view. It said it thinks it's society as a whole, not the persecutor's view that matters. So when the circuit court cases were remanded to the BIA, it basically issued two decisions back to back, matter of MEVG and matter of WGR. And these are the two decisions that are often cited as sort of clarifying what these words mean, although I would say it's still quite not clear enough for most people. So in MEVG, the board said that social visibility does not mean literal visibility or ocular visibility, meaning you don't have to see it with your eye. It doesn't have to be a trait you can see with your eye. It has to do with perception, so whether society perceives the group as distinct from the rest of society. And to make that really clear, the board renamed visibility social distinction. So that's what it's called now. And as I mentioned, it's not in the eyes of the persecutor, it's in the eyes of society at large. Then MEVG also included some language about what kinds of evidence can be used to show social distinction. And so what was mentioned there were country conditions report, expert witness testimony, discriminatory laws and policies, and historical animosities and the like. But a lot of practitioners still were unsure how to sort of prove up social distinction. And you can only imagine for people who are pro se, how hard it would be to try to establish this sort of sociological existence of a group. Okay, so the next case was matter of WGR. I think they were issued on the same day almost. So I'm not even sure which one came first at this point. But basically in that case, it was a group defined based on former gang members. And the board said that was not particular because it was too broad or diffuse a group. And it had this language about, oh, this group can include people of any age, sex, or background, even though in matter of CA, the board had specifically said that the group does not have to be homogeneous. And circuit courts had held that a group does not have to be homogeneous. So we still to this day have sort of this inconsistent analysis from the BIA and also within some circuits now as to whether a group has to be homogeneous. You can think of almost every group out there is going to have a diversity in age, sex, and background, right? I mean, none of the groups that I mentioned that had been recognized need to have people who are the same age, sex, and background. They just have one united sort of characteristic, but not everything about them needs to be similar. So the former gang members did not fly with the board, even though they had that past immutable sort of trait. Not that different than former members of the military or former members of the police, but I think because they were gang members, right, the board did not want to recognize that group, even though the Seventh Circuit did recognize that group. And the former membership had been around a really long time as a way to define a group. So what we have right now is they sort of call these the Scylla and Charybdis of asylum law, the two particularity and social distinction requirements. And that's because once you meet one, it's very hard to meet the other or vice versa. So if you define a group specifically enough that you can clearly tell who's in the group and out of the group. So you're not using words like young, wealthy, intellectual, westernized, which are arguably all too vague to satisfy particularity, right? We don't really know who qualifies as young or who qualifies as wealthy. So you're not going to use those words. And then you start defining a group like El Salvadoran, boys age, 16 to 25 or something like that. Now that's too specific, right? We know who's in the group and who's out of the group, so we can check the box on particularity, but society doesn't recognize boys or young men of that age as sort of a group. And so it'll be rejected on social distinction grounds. And so attorneys sort of found themselves caught between these two requirements where it was very hard to meet both of them. The kinds of common parlance used, the words you would generally use to describe people would not fly under particularity, but the two specific definitions would not fly under distinction. So some of the critiques of these two requirements were related to the evidentiary burden involved, the kind of evidence that you have to produce that most people who are pro se don't know about or can't get, and people who are in detention definitely don't have access to if they don't have counsel. So not just human rights reports, but usually expert testimony is almost necessary in many cases to show a group exists under these requirements. And when that evidence is not provided, it really invites speculation or assumptions by the IJs about how the society in question views people and various groups. It also makes the PSG ground really different than any of the other grounds. So in all of these other grounds, political opinion, race, religion, right? It doesn't matter if you're saying the religion is Catholic, say, it doesn't matter that there are Catholics of all different ages and sexes and backgrounds, right? It doesn't matter how society views Catholics. It doesn't matter like what exactly we mean by Catholicism, right? None of those types of additional requirements are piled. But for the social group ground, we have this piling on of different requirements and making this ground particularly difficult to prove and really undercutting that justem generis approach that the board started out with, where you're looking for a way to define all 5 grounds in a similar way. So after MAVG and WGR, so actually all in the same year, all in 2014, we also got matter of ARCG, which is, I should say, I don't know what's going on with my PowerPoint here, sorry guys, but this was the main precedent on domestic violence until it was overruled by the Attorney General in matter of AB. So in matter of ARCG, the board held that married women in Guatemala who are unable to leave their relationship constitutes a social group. Now you probably are looking at that and thinking, that's a weird definition, right? And it is. It is kind of a weird definition. And the reason it's there is because DHS agreed to that definition. In briefing that was done years before in a couple other DV cases, matter of RA and matter of LH, I think, this group was floated, right? And sort of there was a consensus between DHS attorneys and the applicants' attorneys that this group could work. So the immutable characteristics here, it's gender is part of it, right? Because we have women in it. And the inability to leave is also part of the immutable characteristic in this group. And in ARCG, nexus actually was not contested. So nexus is the relationship, it's the on account of part of the refugee definition. So you have to show persecution on account of one of the 5 grounds. And so you have to show that the persecution, right, is basically because of the person is being persecuted because of their membership in the social group. And that often is itself very difficult to show. And in this case, it wasn't contested. So that often remains a big issue in other cases. Notice that this group can include people of different backgrounds, right? So it's not a homogeneous group. And here in this case too, the BIA did mention things about what kinds of evidence you can use to show social distinction. And some of the things mentioned were the country's criminal laws, whether they're designed to protect victims of domestic abuse, whether they're enforced, and other social political factors. So this was a really important decision because once this came out, people had a way to define the social group in DV cases. And even in cases where women were not married, where they were single, judges were still recognizing social groups. So the fact that they were married was not really a key part of this decision, I would say, or the definition of the group, as much as the inability to leave. So then matter of AB came down under this administration and overruled it, basically saying that the reasoning was bad, right? And AB didn't really create any new asylum standards. There were arguments that it, did sort of raise the standard for persecution by non-state actors and other things, but the circuit courts, for the most part, didn't think of it as establishing any brand new standards. The bad thing it really did was get rid of ARCG, I would say. And it's important to remember that AB doesn't say that the social group recognized in ARCG can never be viable. So people are still using that same definition to argue DV cases in many states. But some places like the Fifth Circuit have post-AB rejected social groups defined very similarly or exactly as they were in ARCG. So it really depends on the circuit. There was also dicta in AB that was really bad, where the Attorney General said that certain claims generally don't qualify for asylum at all. And he specifically mentioned domestic violence and gang violence. Thankfully, in a case argued in DC that was challenging sort of the USCIS memo for doing credible fear interviews, which are sort of the threshold screening for asylum to be able to get into court to do an asylum case. The DC Circuit said that that dicta, you know, is wrong, basically, that you can't categorically exclude entire types of cases and say these generally aren't feasible. Because what was happening is after that dicta came out and was also included in the USCIS memo, asylum officers were just rejecting every single DV-based or gang-based case without doing an individualized analysis that's required. And matter of AB sort of conflates nexus, persecution, and PSG, which makes the analysis very convoluted. So there's language in there about sort of how this is private violence, and that doesn't meet the nexus standard. So post-AB circuit court decisions vary quite a bit. So this is a big contrast, right, between the First and the Fifth Circuit, where the First Circuit has basically said, you know, it vacated a BIA decision that relied on AB in rejecting a social group defined the way it was in ARCG, so an unable to leave the relationship social group. And there, the First Circuit even suggested that, hey, gender and nationality alone might be a good fit for a social group. But in that case, it hadn't been framed that way below, so the petitioner couldn't define it that way on appeal. The Fifth Circuit, on the other hand, where I am, we have a really bad decision called Gonzalez-Belize, where the court upheld a BIA decision that just basically relied on AB and suggested that that social group definition isn't going to work anymore because it is too circular. That you're defining the group in terms of the harm, that the inability to leave the relationship is actually part of the harm and not should not be a basis for defining the group. And then the Fifth Circuit also said it's too broad and diverse a group. So in other circuits, like the Sixth Circuit and the Ninth Circuit, have also issued decisions post-AB. These are better decisions than the Fifth Circuit. They're basically reversing BIA decisions. So for example, the Ninth Circuit said that, you know, the BIA was wrong to treat AB's prohibition on mentioning the harm as making this sort of a circular group. And you can't just preclude PSG based on inability to leave. That persecution can create social distinction, and you can still have an immutable characteristic that exists independent of the harm. So I want to go over some tips on how to define social groups and things like that, and then do some hypos with you guys. So one thing to avoid, I would say, despite that Ninth Circuit decision I just mentioned, is to avoid circular definitions. So what that means is don't define the group in terms of the persecution suffered or feared. Like you can't have a group defined as women who've experienced domestic violence, or girls who have been trafficked, or even child soldiers if you're going to define them in terms of the harm they experience, right? You want to really avoid that as much as possible. Sometimes those groups have been recognized by circuit courts, and I'll share a few of them with you, but I would still, as a general matter, avoid them wherever possible. The second bullet point is kind of just that, try to find that sweet space to satisfy both particularity and social distinction, where you're not too vague, but also not too specific. It's important to look at circuit court case law on homogeneity. So whether the circuit has said anything about, does a group have to be homogeneous? If you're in a circuit that has explicitly rejected that requirement, then that's really good, and that will help you establish particularity. There are some PSGs at this point that have been rejected so many times, like resistance to gangs, that I would avoid that and just try to define your group in a different way or under a different ground. So political opinion might be a better tactic in some of these cases than PSG, where you're talking about resistance, or religion. So I think one of the PSGs I showed you, I think it was SEG, where it was based in part on the applicant's moral or religious views. Bring that as a straight up religion claim and not as a PSG where you have all of these different requirements to meet. Because if it's somebody's religious values that are motivating them to stand up to the gang, then you can argue that on religion. In some cases, it's helped to add words to the social group to actually emphasize the things about it that make it socially distinct or visible. So an example here is Temu, a Fourth Circuit case, where it wasn't just defined as individuals with bipolar disorder, but people with bipolar disorder who exhibit erratic behavior. And I thought that was a very sort of, interesting and creative and good way to define the group, because now it's focused on what people see about the group, even if they don't necessarily know the person has bipolar disorder, they're seeing the erratic behavior. And that's kind of how society recognizes people as different. In terms of evidence, there's, just to summarize some of the types of evidence, you can get declarations from community programs or community organizations, right? Places within the country that can talk about how different people or groups there are perceived. You can get expert declarations. Often these are experts in the US, but they could be anywhere in the world, addressing things like social distinction and particularity. You want to make sure to work facts into the applicant's own declaration that help establish social distinction and particularity. Country conditions reports, if they talk about the groups at issue, that helps show that they're groups. Discriminatory laws and policies, or the absence of protective laws as an ARCG can be used to show social distinction. How the laws are enforced is relevant, and historical animosity. So these are things that have actually been mentioned in decisions as the types of evidence that can help show distinction and particularity. And whenever you have a case based on social group, if you have the capacity and the time, I would definitely recommend briefing the issue. And in part, this is because of a recent decision called Matter of WYC and HOB. This was a 2018 BIA decision where the board actually says you must provide a, quote, exact delineation of the group to the immigration judge. And you can't revise your group on appeal. So combined, those two things are a very rigorous requirement where you're basically waiving any groups that you don't raise in immigration court. So it's important to give that exact definition to the judge. And if you do that in writing, that's the surest way to preserve it for appeal and make sure that it's considered. And when you're doing your brief, you want to address each element for asylum separately, as well as each social requirement for a social group separately. So the three: immutability, distinction, and particularity. Brief each of those separately. And of course, nexus makes this all much more complicated. I know we haven't talked a lot about nexus, but I'm happy to answer questions about it because often that is as challenging, if not more challenging, than social group. And because there is now so much variation among the circuits, you definitely want to do the research on Westlaw or Lexis to pull up those circuit court cases that might help you and might be actually much better than some of the BIA decisions we've been talking about. Because you could argue that those circuit court decisions are still good law even after some of the BIA decisions that are more limiting. Okay, so I wanted to do a few hypos with people. So I guess for these, I'm gonna just ask you guys to not mute yourselves if you've muted yourselves. And
Professor Marouf, can I just interrupt for 1 second? I think your slides might be stuck. I can still see a slide that says defining a PSG. So if you have a hypo slide.
I do.
We haven't moved on
I
yet.
don't know what's going on with the slides. Yeah, they're moving on their own without my touching anything, which has never happened. So do you see a hypo slide now?
No, no, at the moment I see defining a PSG.
Defining a PSG.
Where you were talking about Timu and v Holder. That was the last slide.
So that's stuck a long time
Shafali,
ago.
do you have the same thing? Yeah, we all have the same thing. So the last slide we saw.
Okay. All right.
I was going to interrupt you earlier, but I thought I'd wait. Sorry, apologize.
Okay, that's okay. I'm gonna just try this and see, does this help at all?
Try unsharing your screen and then resharing it.
Okay.
Great. Now we're on the hypos.
Okay. I apologize for that. So
no problem.
Probably was talking too fast too. Okay, so I told you guys about Temu, right? The case with the people with bipolar disorder who exhibit erratic behavior. So what do you guys think about a group defined as people with mental illness? And I'm giving you some cases here that might help you think about how to define it. You can see, if you look quickly at this list, some circuits have accepted this group and some have rejected it. Like the Eighth Circuit in Raffington rejected this group, whereas the Seventh Circuit at least reversed the decision that had rejected this group. But I'm curious what you all think in terms of immutability, social distinction, and particularity. What would be the challenges with this group? Like, let's start with immutability. What would be possible difficulties showing immutability with this group?
So people can just unmute themselves and chime in, so or they can raise their hand if they want to be called on.
Is this easier if I stop the share? Maybe I'll do that. And then I can share it again.
Would you like to just restate the question? And then we have Pamela, who's raised her hand.
Sorry, I can see the hand. Okay. So the question was, what challenges to immutability do you see with the group defined as people with mental illness? And Pamela?
Hi, yeah, I was just gonna say, I think that part of mental illness is people do try to mute that characteristic, and people often characterize mental illness as something that you can't really see from the outside a lot of the time. So if it's just people with mental illness, you can't really necessarily see that. So, and some people, it sometimes actually is mutable, you know, so.
Right. So you can treat it, right, with drugs maybe. So that's a possible challenge, right? And then do we have to be able to see it?
So I would say that the visibility issue is complicated with mental illness, but at least from places in certain countries in West Africa where often mentally ill people are chained up, right? So in Nigeria and Togo and Ghana, where we have these horrific country conditions where people are chained up, there is actually or they're sent to witches' camps. There are various other types of places. They then become visible through their social treatment.
Great. Yeah, we just did a couple cases on Somalia where they used chaining, and but I mean, again, there's no right or wrong answer on this. Because there is that bad Eighth Circuit decision and a good Fourth Circuit decision with a more narrowly defined group. What I've done in my cases, and I mean, Eunice or others can chime in if you've had other experiences, but usually we try to be a little more specific about what the mental illness is. So if it's schizophrenia, we'll say people with schizophrenia, and then often we'll just add what Temu had about exhibiting erratic behavior, or people with bipolar disorder, whatever the illness is, to try to be a little bit more specific about it. But absolutely the country matters in terms of who is stigmatized, right? Is everybody with any kind of mental illness stigmatized? Or is it just certain types? Like, would depression be stigmatized in the same way as schizophrenia, or is it more like the behavior, right? That is the stigmatizing thing. So thinking through each of those things is really important to figure out who is it that society perceives as different. And then the question of treatment adds you know, you could argue it's immutable because it can't be cured even though it's treatable. But these are all things to like think about and discuss in a brief, and not just assume that the court will kind of be with you on each prong of the test. What about particularity? Like you have to be able to tell like who has mental illness and who doesn't. That's kind of tough, right? That's a little bit vague. So that's another reason to go narrower with your group. If you say people with schizophrenia, you can apply a diagnostic test. You can say, hey, the DSM-4 or 5 or whatever defines exactly who has schizophrenia, who meets these symptoms. And so it is a particularly defined group. So that's another reason. Okay, I'm gonna go ask you guys another question. Family is a social group. So let me see here if I can share my screen again. Can you guys see this slide on family as a social group? So matter of LEA is another recent case on social group that's didn't come out as badly as it could have, because we were worried that the AG would impose what's called a double nexus. So not just that your relationship to a family member creates a social group, but that family member has to be targeted for a protected ground, so that there need to be 2 levels of nexus, basically. That did not happen, thankfully. But there's bad dicta in there too about sort of nuclear families generally not being social groups because they're not socially distinct. So again, it's not a categorical exclusion of family as a social group, but there's bad language in there that is probably leading to a lot more family-based cases being denied. And remember, family goes back all the way to Matter of Acosta, where the board said kinship ties can be a social group. So if you had a nuclear family in your case, I just put John Smith here, but whoever your client is or the applicant is, right? How might you try to define the social group? Or what do you think of this definition, and would you change it in any way? I'll stop this screen share here so I can see you guys better.
And people should just feel to chime in or raise their hand.
Yeah, just chime in. I may not see the hands.
So while we're waiting for someone else to chime in, I'll say from Togo, for example, if you happen to have a name like Olympio or D'Souza or Dalmeida, these are people who are the living descendants of the former slave traders who resettled in West Africa from Brazil, and they're associated with the independence movement. So they're associated with the political party that the current regime's father overthrew. So even though their names, even though their family may be nuclear or otherwise, just having a name that is Afro-Brazilian, immediately they're assumed to be a member of the opposition party. And so their family name becomes a proxy for opposition activity. That's
great. That's a terrific example. I think that would be a much stronger case than the typical sort of case we see. The reason family comes up a lot for Central Americans is because it's kind of sometimes an alternative way of arguing a DV case. If you want to argue that somebody's, say, wife and children have been abused, you can say family members of that person and try to use that as the social group. But after LEA, that's going to be, I think, harder to win those groups defined in that way. Other thoughts on?
Sure, what I would do. So what I would do is I would say immediate family of John Smith, probably the Smith family. I'm not sure if you do this, but when we brief it, we usually, in the past, I've offered numerous formulations of a similar group and then argued them kind of together. And then the other thing I would do is argue exactly the LEA social group to set it up for a challenge to be reversed at, up in the Court of Appeals. So that's probably what I would do.
That's a good strategy in the Ninth Circuit. Not so much in this.
It depends on where we're sitting, for sure.
Yeah. No, but so you bring up a great point about multiple social groups. So you can always argue multiple social groups, and usually you should, and we do, because you want to kind of give the judge their pick, right? Here's like 3 or 4 or 5 options, whichever one you like the most, judge, especially with gender or the other ones that are a bit tricky, because it might just be that your judge has a preference for one over the other, especially now after WYC, where you have to give an exact delineation. You might as well just, and you can't create new ones on appeal, you should just put them all down at the immigration court level. The last type I was going to give you, I won't do the screen share again, but just in terms of gender, is about, you know, how to define stuff post AB. And I mean, you have Eunice here as an expert on this. But what about if we just went back to, say, gender and nationality? So Salvadoran women, how do you think that would work now? Would you do that? I mean, it's probably would be one of the mix, I would say, right? There are actually some cases, like IJ decisions right after AB, some really good IJ decisions that came out from different, around the country, where judges were basically going back to that and saying, we're just gonna recognize gender and nationality as a social group. In terms of circuit court cases, we do have some. It is still pretty limited, but there are a number of them out there. In the Ninth Circuit, there's Mohammed v. Gonzalez, which recognized Somali females as a group, and in Perdomo v. Holder, the court remanded to decide if Guatemalan women is cognizable, so it didn't outright reject that. The Eighth Circuit has recognized Cameroonian widows as a group. And there's some Eighth Circuit has also recognized Somali women. So those are, you know, it's not like it's never been done. And I would say that would probably be the correct way to define the group. And the reason it hasn't been done that way is out of sort of fear of opening the floodgates. But you have to remember that just because a social group is defined as, say, Salvadoran women, does not mean all Salvadoran women can now get asylum, right? You still have to meet every other element of that asylum definition, which is going to narrow it substantially. I don't know, Eunice, if you have any other tips on post-AB definitions.
Fatma, I wanted to ask you,
or Shafali, yeah.
Professor Marouf, I wanted to ask you a question about that idea of, you know, just Salvadoran women or Guatemalan women. Do you think it's more likely that the courts and potentially even the BIA would be more likely to view that as a particular social group, you know, given that all the other requirements are met, in those instances where the persecution is something that's clearly recognized as something that doesn't happen in Western culture? So in other words, when you see it in the context of DV, well, we have DV here too. So at least from what I've seen, the courts are much less likely to view that as a persecuted group. But when you're looking at female genital cutting, on the other hand, something that's really abhorrent to Western culture and values, then you're maybe more likely to have a PSG work in that way.
I think absolutely. You know, I mean, the first thing I noticed when I was sort of putting together the list of cases is that almost all of the countries, maybe with the exception of the Guatemalan women one, it's all women from Africa or the Middle East, where courts are kind of willing to be like, okay, Somali women, you know, Cameroonian widows, because it's seen as the harm being so pervasive or so different in nature, like FGM, that it just seems like different to them than recognizing DV. So I completely agree with you that there's a sort of an especially foreign element to it that takes it to a different place in the judge's mind. And it's very hard somehow to extend that logic to Central America for some reason.
I could share a tidbit on the nationality plus gender social group. Yeah. So one interesting that happened in the matter of AB case, we represented Ms. AB when I was part of the center, and DHS in its brief to the Attorney General actually did not argue for the overruling of ARCG. They supported that precedent as precedent, and in fact pointed out to the AG that if you overrule the ARCG case with this very specific social group of married Guatemalan women who cannot leave their relationship, then you might get a flood of gender plus nationality cases, and those would be even more harmful for the asylum system in DHS's view. So I think there is some recognition or worry on the part of DHS that getting rid of ARCG would lead to precisely that social group. So our strategy, when I was at the center, was to take that and run with it and put gender, nationality in every social group for every DV or gender related case subsequent to AB.
Right. I mean, I think gender and nationality checks all the boxes very simply. Like every society recognizes women or men as distinct from each other. Every society like generally understands who's a woman or who's a man, right? It's silly to think that we have somehow limited this group out of the read this group out of the definition just because of our fear of the floodgates. But
agreed. Definitely.
So I'm happy to, sorry, I think I talked longer than I intended, but I'm happy to take any questions anyone has.
So, well, thank you very much, Professor Marouf. Everybody, I'm sure really appreciated your presentation. Yes, I think we have probably a couple of questions from the group, from the audience. You can either raise your hand. I think I saw Pamela Riola's had a question at one moment. So I also have some questions as well, which we can turn to depending on how the conversation goes. So is it, yeah, Pamela, would you like to, and invite everyone to turn on their cameras and raise their hands, or just to put in the chat function if you have a question.
Yeah, so my question is going back to the family as a social group prong, and I was wondering, I have two questions, I guess. So the first is, did you see the Fourth Circuit case that came down this week, saying that there was an immediate family, it was like Hernandez Cartagena, saying that there's an immediate family recognizing that. It seemed like they were maybe recognizing it as a group. It was a really confusing opinion and really short, but I guess I was wondering if you'd seen it and what your thoughts on it were, but.
Sorry, I haven't.
That's okay. And then my second.
You think they did recognize it?
Yeah, I mean, my interpretation for the purposes of my asylum work is going to be that they recognized it, but yeah, if anyone had seen it, I was going to ask. But my other question was, do you think with family as a social group, like, is it a good idea to kind of include maybe, like you say, family members of those who are persecuted based on their political opinion or something? So you add that, even though the double nexus isn't required under LEA, maybe making that double nexus would help win your case?
I think if you have it, if it's there in your facts, then I can only help, I think, to include it. And you never know when another decision is going to come down, adding that. So I think, as long as you can argue it based on your facts, absolutely, I would. Yeah.
Great question. Other questions from the audience? I didn't see any hands raised, so I'm gonna, I've shared with Professor Marouf a couple of questions, some of which we've already touched on. So, but let me start more broadly. I wanted to ask you, because you hinted at this at the beginning, but I'm a historian, and I'm always trying to make sense of the history of this convention and how it came to be the way it is. So I'm wondering where you sit vis-a-vis the different theories about how the PSG emerged back in the 1950s. Like, what do you think the drafters of the convention were trying to account for? And you're probably familiar with the different theories, but for those in the room who are less familiar, there are lots of different ones, but they kind of boil down to two groups. Like, there's the people who think it was backward looking at what the Nazis had done specifically and how they targeted people that previously hadn't been targeted. And then there's the sort of forward-looking theory, which is that we're looking for the groups of people that may yet be targeted because we hadn't yet anticipated in the 1930s what Nazis would do, for example, to mentally ill or LGBT or Jehovah's Witnesses and so forth. But that's just one way of thinking about it. So I'm just wondering, what your thoughts are.
I think I'm sure you know more about the history than I do, honestly, but I mean, I have read about it more in the forward-thinking sense of not knowing who will be persecuted in the future, that these are the reasons that we understand persecution has happened before, but kind of leaving sort of a placeholder for other groups we may not have anticipated. But I think you probably have a better sense of how that all got hashed out back then than I do.
Well, I'm not sure. I mean, I think it's still, I think among historians of immigration law, it's still very much a debate, right? And I don't know even if one or the other or some alternative theory is more helpful for advancing particular cases today, right? So, so I'm curious about your thoughts about that. So, do you think the sort of forward thinking is a more helpful way to articulate a potentially new type of claim or a new type of particular social group before judges that have not heard something like this before?
I think it's possible. I think judges in general, in the US at least, are not looking that much at the historical context or even at the international context, shockingly. So even though the Supreme Court has said, our asylum law is based on this convention and was made to give effect to our obligations under this convention, courts rarely talk about any of the sort of international ways of interpreting a convention. Like, you never see them recognize the Vienna Convention on how to interpret treaties or anything like that. You don't see them looking at our sister signatories. You don't see them looking at sort of whether practice has emerged, has sort of coalesced under certain interpretations or anything like that. So I honestly don't think it will make that much difference, at least in the US. It's possible that other countries that do take a more international sort of view of things will approach it differently. I think, the forward-looking theory is very consistent with sort of what was in Acosta, in the sense of these are the types of things that we're looking for, things you can't change or shouldn't have to change, right? So in that sense, it's concrete enough that you understand what types of traits might be protected, but it's open to things that we might not recognize, like even gender identity or sexual orientation at that time probably that was not on anybody's minds, or maybe it was, but it wasn't written down, and now decades later it's explicitly sort of protected under that group. So yeah, I think it's an evolving thing.
Well, so continuing on that theme then, what do you think about do you, as a practitioner as well as a theorist and teacher, what do you think about the relative helpfulness or unhelpfulness that PSG has evolved differently in diverse jurisdictions around the world? And how easily can you draw on the way, for example, the Netherlands or Sweden or Britain have thought about these terms? You mentioned some of this in your talk, specifically how Britain stepped back from something. And I'm familiar with the UK and the US, but very little beyond. So I don't suggest there's something specifically I'm looking to, but I'm just wondering, as a practitioner, how helpful is it that there are alternative theories floating around in other countries?
I mean, I think it's helpful to be able to look at them and look for, is there a pattern or not? I found it when I was sort of working on researching this issue for both scholarship and for like an amicus brief, like that it is not that easy for us to actually learn about what other countries are doing. There's not enough being published in accessible sort of places for us to on this kind of level of specificity, like how different countries are interpreting a social group. Asylum decisions in other countries are not easily accessible, so we're really only getting sometimes the highest courts, and often only in common law countries. And for non-common law countries, it's even harder to figure out what their law is, especially when it's not in English and it's not, just not as easily accessible. So I found that I was looking at pretty dated cases when I was looking at it. I honestly don't even know currently how countries have changed post the EU. The EU has made it a lot easier because they're now on a common track. They have the Qualification Directive. There are countries like the UK that have opted out of the whole, Qualification Directive, and the whole sort of the EU is going for a common asylum system for all of Europe, basically. But countries like the UK have opted out of that, from what I understand. So, it's not there is more consensus than there was. There's more common interpretation than there was because of the Qualification Directive. But there's still so many countries that are outside of the EU that I think we don't know enough about what's going on, including, I mean, South Africa has tons of refugees, is a common law country, but it wasn't that easy to find South African cases, for example, and it's in English, but still, it's just not as accessible. And they may not be deciding as sort of, they may not be issuing all the written decisions that we sort of do here. So it might just be happening without being written down and sort of memorialized in a way that's, it's easy for other people to study and understand the thinking behind social group analysis.
Very interesting. So I guess sort of continuing that train of thought and keeping in mind that I'm like 1L and I'm just coming to terms with some of these concepts, such as the idea of mandatory versus persuasive authority and things like that. Right. So in my own expert report, sometimes, for example, like a Togo case recently, there is a case that came out of a Swiss court where they talked about the specific things this gentleman had done that had provoked the ire of the authorities, resulted in his detention. So, you know, when I have a case that I'm writing about as an expert, I talk about the specific, he was handing out flyers or he was distributing t-shirts. This is just like this case in Switzerland, right? Of course, I'm just writing the expert report, so I'm not offering it or advancing it. But I'm wondering how you advise practitioners to bring into conversation, or sorry, to bring into your documentation that you're preparing for a case. How do you fold in cases from other countries that are relevant? I realize there is the persuasive authority dimension, but what I mean is beyond thinking like that. What is the more effective way, or the more particularly effective strategies?
Yeah, through, at least at the appellate court level. Usually it doesn't come in at all at the immigration court or BIA level. And if it comes in at the appellate court level, it comes in through an amicus brief, meaning a friend of the court brief. And that's usually because there's enough US law to talk about for the petitioners to discuss in their own brief that will take up their word limit, but also because they know courts are not likely to look at it. So they kind of save that stuff for a, you know, if you guys have time, if you're really interested, here's what these other 10 countries are doing. You know, sometimes you will see in court decisions, discussion sites to a US, to a UK House of Lords decision or something, but I would say that's pretty rare. Even cites to the convention are pretty rare.
Pamela?
So I think,
sorry, please continue.
I'm done. Go ahead.
Hi, sorry, I know I have a lot of questions, but I was wondering, something I've been struggling with is formulating particular social groups where there potentially, or there isn't really any past persecution. Like, I think it's much harder to really have a particular definition where there's no past persecution. So I was wondering if you had any tips or pointers on that.
And the fear of persecution is what kind of harm? If you have a specific example.
Sure, let me just think of how to change some facts. So for example, maybe like I'm thinking in terms of family a lot, because that's coming up a lot for me. And just like, say your family members are being persecuted, but you've been in the US on like a student visa for a long time and you've never expressed these views, but you know, if you go back and if all your family members are being persecuted, but you yourself have never experienced any past persecution, how do you go about that?
I think I would define it the same way. I don't think the absence of past persecution would necessarily change, at least based on in this kind of situation. I don't see how it would change my definition of the group. I think I would still go with family. And it sounds like if the family members who have been persecuted are expressing some kind of opinion, right, I would go with the imputed political opinion or whatever. So every ground, so everybody knows every ground can be imputed as well as actual, meaning other people think you have it even if you don't have the correct characteristic.
So you can do, I've been looking at the case, like you can do imputed political opinion where there's no past persecution?
Yeah, you can impute anything. Okay.
That's actually a great transition to the next question I want to talk about, which is country conditions expertise. So, you know, in the last few years, I've had this sudden bunch of cases about imputed homosexuality, right? So men, and in one case, a woman from Nigeria, from Ghana, who have gay friends or have been hanging out with gay people and have been similarly attacked. And so in most of the cases, I think they've been successful. So so I'm wondering if you could talk a little bit about your role working with expert country conditions. How do you articulate that role when you're explaining it to your students in your clinic? And what do you think future immigration lawyers should be thinking about in terms of country conditions expertise?
So experts are invaluable. Thank you for doing all those expert decks, because they usually are what can win you a case. The experts are helpful in multiple ways. One of the most helpful ways is to weigh in on the risk of future persecution. And in my experience, getting some type of predictive probability of the risk of future harm from an expert is really critical, because otherwise a judge can look at everything and still say, yeah, but I just don't think you've established, you know, if it's a withholding case, a greater than 50% chance of persecution, or if it's asylum, a reasonable chance of persecution. Whereas if the expert has said, hey, you know, there's like a 90% chance this guy's going to be chained and put in a mental institution if he goes back, it's much harder for the judge to then just say, I just don't think it's likely to happen, right? He's going to have a lot of other evidence on the other side in order to conclude that. And in the Ninth Circuit, I argued a case called Cole that's really good on expert stuff, and basically says, you know, a judge is not just free to ignore expert testimony or predictive probability like that. Experts are also great on addressing issues that are not covered in like State Department reports. So a lot of the things, Professor Lawrence, that you mentioned, like, are pretty, you know, unusual things maybe that the State Department report might have a few sentences on or nothing on, right? And so, and there might not be other reports filling those gaps either. So you really need somebody with deep knowledge of the country to be able to explain that to the court. So those are all really important things. And other times judges just think the type of persecution somebody experiences is not plausible because it's not familiar to the judge, it's not within their experience. So for an expert to weigh in and say, hey, this type of treatment or torture or whatever it is actually common in that country, makes it more plausible for the judge.
So actually, you touched on the next thing, or the related question, which is when you give instructions to experts, or with, well, what in Britain they call it an instruction to an expert. So in the United States, when you make a request to an expert, or you ask, could you assist with this particular case, how concrete do you like to be? So I love it, for example, if someone says, hey, we need to know this thing. And then I write, okay, I can or I cannot address that thing. But then there are some experts who don't like to be told, right? They resist that. So how do you balance that? How do you navigate that?
So usually I will send them the declaration, and I will, before I ask them to be an expert, kind of get their views on the case. So if their view is like, hey, this person just is not a strong case, I usually won't then ask them to be an expert, right? Because I don't want somebody who doesn't feel like this is a good case. But then, yeah, I think I am pretty detailed about what I would like from the expert declaration. So I know what the weaknesses in the case are, or by weaknesses, I mean the gaps I need the expert to fill. And so I can say, hey, can you touch on these specific issues? And I usually will say, do you feel comfortable predicting the risk of future harm? And sometimes they do, and sometimes they don't. And I'm not expecting them to say there's like a 63% chance, right? But to the extent they can give me something, that can be very helpful. Whether or not they make a legal conclusion, that's usually less helpful sometimes. Like if they use the exact sort of legal test, I think judges sometimes don't like that because they don't want the expert to make the final sort of call on the legal test. They want to make that call themselves. Right.
That's great, actually. You know, that's specifically like in Britain, the credibility question of the use of plausible, like these terms that we think are somewhat interchangeable in US contexts, are really policed. But anyway, we've come to the end of our 1 hour and 15 minutes. So I would like to thank you profoundly for sharing your expertise and your wisdom with us today. It's been really enlightening. And I know my peers and my colleagues and my professors have learned a lot. So please join me all in thanking Professor Marouf for sharing her time with us today and being part of the Bacon series.
Thank you all. Great to see you.
Thank you.
Thank you. Stay healthy and mask up.
Thank you so much.